Hi, my name is Richard Coulthard. I'm a partner and head of corporate at Harrison Solicitors. Ideally, a business owner needs to be thinking about this at least 2 to 3 years in advance of when they plan to sell the business. One of the key practical issues to consider is who is it that's actually going to buy the business? Is it going to be bought by an existing management team? Is it going to get passed down to a friend or relative? Or is it going to be bought by a third party, maybe a competitor or a private equity group? If it's getting sold into a management team, for instance, that has the advantage that they will understand the business and the client base. However, it may well be that the management team do not have sufficient practical expertise to run that business. Therefore, you may need to consider training of that management team. During the sale of a business, we go through a process what's known as due diligence. This is where a buyer will request certain documents to be reviewed and for certain warranties to be given. What can happen is that if that due diligence process reveals information which is unfavourable to the business owner who's selling, it can result in either deals falling apart or in the value of that business decreasing. One of the documents that I would recommend that all business owners of any age have in place is a lasting powers of attorney. The purpose of having a legal and financial lasting power of attorney is so that if a business owner becomes incapacitated, there's someone else or other persons who have the authority to control their financial affairs, including the business financial affairs, whilst that person is incapacitated. Another document is worthwhile having would be a will, because this will deal with the business owner's desires as to what will happen with the shares or the business upon that person's death. If you need more information, please feel free to call on 0113 284 5000.